justice. Her practice focuses on protecting economic liberty, private property rights, free speech, and educational choice. And we're privileged to have her here to speak about how the policy world often inhibits the ability of markets to meet people's mental health care needs. Please join me in welcoming Jaimie Cavanaugh to the lectern.
Thank you, Noah, and thanks everyone for being here today. This is great. So let's see, I'll start just with a quick agenda so you'll know what we're running through. We'll start by talking about legal barriers to building more psychiatric facilities, and the main barrier there is what's called Certificate of Need laws, and we'll discuss what those are. And then we'll talk about the barriers to increasing accessibility to available mental health professionals. And some of those barriers are telehealth laws, occupational licensing, and scope of practice laws. So that's where we're going. Let's jump right in. And I wanted to start with a story I read recently about a Michigan resident. She's in the middle. Ashlyn Barker is her name. She's there with her parents. And Ashlyn's story started about a year ago. She was 15 at the time, and she was struggling with an eating disorder. Her parents and her doctors realized that she needed inpatient psychiatric care. And so Ashlyn's parents started looking for a facility that could take her. And unfortunately, her mother was told that all the beds in Michigan were full. So her mom kept at it and was on waiting lists and was trying to seek the best treatment she could for her daughter. But sadly, while they waited for a bed to open up, Ashlyn's condition deteriorated, and she ended up, over the span of months, at the end of it, weighing only 87 pounds. She lost so much weight during this time period. So she waited 4 months for a bed, and the kicker is that bed that opened up for her was in Wisconsin. So if she had needed a bed in Michigan, she would have had to wait even longer. So this is just a quick example of the need for psychiatric care facilities in Michigan and beds. And it's a known fact in Michigan that Michigan has a critical shortage of psychiatric care beds. There's about 399 beds statewide for children and adolescents, and there's between 2,600 and 2,700 beds statewide for adults. And these beds were really during the pandemic, especially for children and adolescents. Like I said, they were often running at full capacity. So I said that the barrier to adding more facilities, psychiatric care facilities and psychiatric beds, is Certificate of Need laws. And I don't expect anyone to know what these laws are. They're pretty obscure. So at the most basic level, a Certificate of Need is a government permission slip to build a new healthcare facility or to add on to an existing healthcare facility. So for our purposes today, a Certificate of Need would be required to build a new psychiatric care facility or for an existing care facility to add beds. And these laws don't address health and safety concerns. There's a separate set of laws that address health and safety standards for these facilities. But the Certificate of Need is really just an initial government hurdle that the providers have to jump over just to get the green light to start moving ahead with their project. And this is a way for the state to tightly control the markets and the number of facilities and the number of beds throughout the state. And they apply to lots of different kinds of medical care, everything from building hospitals and adding regular hospital beds and adding neonatal services, down to things like adding CAT scanners and MRIs. But again, today we're focusing on how they apply to psychiatric services. So this is how the CON application process works. I'm gonna run through an example quickly with hamburgers because for some reason that's the example that everyone who talks about Certificate of Need laws uses. So imagine that you came up with this amazing new hamburger recipe and you're excited to share it with the world, and you decide that you wanna go out and open a restaurant. Now, if Certificate of Need laws applied to hamburgers, then instead of going out and looking for a space to lease and trying to hire staff, you'd have to start by filling out a lengthy application and paying thousands of dollars to the Hamburger board to submit that application. And then you'd have to wait months for the board to decide whether or not they approved your application and whether they decided that more hamburgers were needed in this area. So what does that look like in practice for psychiatric care facilities? So the COM process begins by a psychiatric care facility filling out a lengthy application. And the point of the application is to prove that your services are needed. And the other purpose of the application is to prove that your operation won't harm your competitors' bottom lines. So these are difficult things to prove. So you can't fill this application out on your own. Instead, you have to go hire attorneys and consultants and experts, and these people will crunch the numbers and look at the data and try to help you prove that you won't interfere with your competitors' finances. So after that, this takes a long time and costs a lot of money. Then you'll submit your application to the Michigan Department of Health and Human Services, and just submitting the application costs an additional $3,000 to $18,000. And after that, you'll wait a few months for the department to decide whether or not to grant your certificate of need application. And of course, if your application is denied, then you don't get any refunds on any of the money you just spent. So you can see how this is a barrier or an obstruction to facilities that need to grow. At very least, even if they sail through the process and get their CON application approved, it still costs them money and it still slows them down in responding to the needs of their community. So you might be wondering where certificate of need laws came from. The first certificate of need law was enacted in New York in 1964. Certificate of need laws were created because they were intended to reduce costs and increase access to health care. That was their original goals. And a few other states started enacting certificate of need programs, and Congress took notice. And in 1974, Congress passed a law that required states to enact certificate of need programs in order to be eligible for certain federal reimbursements. So this, of course, coerced all the states, and at one point, every state except Louisiana had a certificate of need program on the books. But then, in 1986, Congress actually admitted that the certificate of need program failed to accomplish its goals, and in a rare admission of policy failure, Congress specifically said that certificate of need laws failed to control healthcare costs and were insensitive to community needs. And ever since that time, the federal government has disavowed CON laws and has done continued research to show that certificate of need laws don't work on the ground. They don't actually meet their goals of increasing access to care or decreasing costs. So like I said, certificate of need laws have failed to meet their purposes. There's a plethora of literature about this, but here's one quote from the Federal Trade Commission and Department of Justice. They did a study together in 2015 and found that rather than keeping healthcare costs down, certificate of need laws and regulations lead to higher prices and expenditures. So it leads to patients paying higher prices, but it also leads to healthcare facilities expending more money. And instead of increasing access to care, the Mercatus Center at the George Mason University has done a lot of research on certificate of needs, and they've found that states with CON laws have access to fewer hospitals, hospital beds, ambulatory surgical centers, dialysis clinics, hospice facilities, and a decreased access to medical imaging technologies. So all things that aren't good for patients. And the flip side of that is, of course, patients in states with certificate of need laws have to travel further distances to access healthcare services. Certificate of need laws can also create a barrier to introducing new technology into a state. So I have an example from Grand Rapids where medical entrepreneur Anthony Chang wanted to invest in a new technology, a brand new type of isotope scanner that could identify cancer faster and quicker than existing technology, and could target the treatment much more efficiently than existing scanners. But unfortunately, when he applied for his certificate of need, instead of the agency being excited that he had this new life-saving technology, the agency said, this doesn't fit into any of our existing laws and regulations, so we're gonna put your application on hold and we're gonna spend a whole year studying your technology, even though the technology was already FDA approved. So this was a time barrier for Mr. Chang. He eventually did get his certificate of need approved, but it shows you kind of another barrier that can come up in the certificate of need process. And the main feature of certificate of need laws is that they give the incumbents, the certificate of need holders, monopoly power over a geographic area. So any medical facility that gets a certificate of need, of course, wants to keep certificate of need laws on the books because they now have a monopoly power over their geographic area. They know that they're not going to have competition coming in, and for that reason, they don't have to ever worry about lowering their prices to stay competitive, and they don't have to worry about updating their technology to stay relevant because they're not in competition with anyone else in their area. So here's a quick look at certificate of need laws around the country. Unfortunately, today, certificate of need laws still exist in 35 states and DC, and then another 3 states, Arizona, Minnesota, and Wisconsin, have quasi-certificate of need laws, so that makes 39 jurisdictions. But nearly 40% of the population actually lives in a state without certificate of need laws, and that's what this map is showing. All the dark blue states are states that don't have certificate of need laws. So we can compare, luckily the analysts, the scientists, and everyone can compare the data and see that certificate of need laws aren't necessary to have a functioning healthcare market. And in fact, the argument often is that if you repeal certificate of need laws, that hospitals will go out of business, but we know that isn't true because all of these states without certificate of need laws have plenty of functioning hospitals, and in fact have more hospitals than the certificate of need states. So what can we learn about certificate of need laws from the pandemic? So this was a really exciting admission by the government that certificate of needs are a barrier to access to care, and that certificate of need laws don't allow for flexibility. So as you might imagine, if hospitals had to ask the government permission just to add beds, if psychiatric care facilities had to ask the government permission just to add beds, this is a process that's too cumbersome to work during the pandemic. Hospitals had to make split-hair decisions to add beds and needed to be able to respond in real time to patient demands on the ground. And so something I always say is if Khan's certificate of need laws increased access to care, we would have seen more of them during the pandemic. States would have wanted more certificate of need laws, but in fact, just the opposite was true. 25 of the 39 Khan jurisdictions actually suspended their certificate of need programs or loosened their requirements. So Michigan took a modest action of allowing existing regulations to come into play, and the regulations allowed healthcare providers to apply for emergency certificate of need based on emergency circumstances. So while other states may have waived their certificate of need requirements altogether and allowed hospitals to do what was best for their patients without any oversight, Michigan still forced healthcare providers to submit paperwork, but had an expedited process for reviewing that paperwork. And again, the emergency Khan applications are only allowed in emergency circumstances. So those circumstances are technically still ongoing, but it's hard to say when those will end. So here's an example of how those emergency certificate of need applications worked on the ground. In spring 2020, the Pine Rest Christian Mental Health Services organization submitted an emergency certificate of need application to add 40 beds at its facility. And this application was granted, but the use was restricted to COVID-19 patients. So this is a psychiatric care facility. So the beds that were added are 40 beds that are restricted to psychiatric care use, but then they also had this additional caveat that the patients using those beds had to be COVID positive. So then last month, the facility filed a second emergency con application and asked that the 40 beds be designated for use by both adults and adolescents, but now without being COVID positive. So they are asking permission to treat members of the general public in these psychiatric care beds without them first being tested for COVID and being positive. So this shows you the level of detail that the agency forces providers to show to the agency, really. They can't just change the designation of these beds on their own. Providers can't change a bed from being for adult use to adolescent use on their own. They have to ask permission for that. And in this case, they can't change the beds used from COVID positive patients to non-COVID positive patients, even though we know there's a severe shortage of beds, mental health care beds in Michigan. But they're still having to jump through all these hoops. And the real kicker is that in the end, when the emergency circumstances end, Pine Rest will have to go through the whole certificate of need application process again, because the emergency con applications are only in place during the emergency circumstances. So it just shows you the amount of paperwork, the amount of time, the amount of money that healthcare companies are spending trying to comply with government rules instead of spending that time and money caring for their patients, or instead of being able to respond in real time to the needs of their patients. So what are some of the solutions to the problems with certificate of need laws? We saw the government during COVID loosen some of the certificate of need restrictions. And so one way of looking at changing certificate of need laws is asking state legislators to make those waivers permanent. If waiving certain certificate of need requirements was safe during the pandemic, then there's no reason it shouldn't be safe all the time. And Michigan has two pending bills right now, SB 181 and SB 190, that would reform the certificate of need process specific to mental health services. But these bills are really hard to get passed, and hospitals come out and protest any type of reform to certificate of need laws because, again, they want the golden ticket, the certificate of need that keeps their competitors out of the market. But change is possible. Last session, Montana got rid of 2/3 of its certificate of need program. Tennessee made some sweeping changes back in 2019. Florida gutted most of its certificate of need program, and now cons only apply to nursing homes in Florida. So change is possible at state capitals. And then the other solution is to challenge con laws in state courts, or in courts. And that's what we do at Institute for Justice, where I work. And so these are some pictures of our clients. On the left, you have Dipendra Tiwari and Kishore Sapkota. These are two clients who are challenging Kentucky's Certificate of Need program as it applies to home health agencies. They wanted to start a home health agency specifically for Nepali-speaking patients, and the state told them they couldn't do that, so they're challenging that in court. And on the right is an IJ client, Mark Nda. He's challenging Nebraska's Certificate of Need law as it applies to non-emergency medical transportation. So he already has a home health agency that can drive his patients to run errands, but he can't drive those same patients, say, to a doctor's appointment or to the pharmacy. So he's challenging the arbitrariness of that. but we don't know how those cases will turn out because they're still ongoing. So those are some of the barriers and some of the ways to hopefully curtail those barriers, specifically for psychiatric facilities and psychiatric beds. But what if we want to talk about accessing medical care providers? We're going to turn now to talk about telehealth, and just so we're on the same page, obviously telehealth is the distribution of healthcare services through digital communications. It can be through text messaging, phone calls, platforms like Zoom, and other digital means. We saw actually during the pandemic that a lot of states had to update their telehealth laws to make the definition of telehealth broader. That's why I use this asynchronous and synchronous term on this slide, because a lot of states had too narrow of a definition, and this is some of the language that they adopted in the wake of the pandemic to make sure that their law allowed for every type of digital communication. And then teletherapy is telehealth, but used specifically for mental health services. So some of the advantages of telehealth are accessibility, convenience, and cost. And I'll mention that accessibility is especially important for people in rural areas. We know rural communities already lack access to medical care. And cost, sometimes telehealth visits are less expensive than in-person visits. Some of the disadvantages are insurance coverage. I know there are lots of fights going on about this, but I'm not an expert in this area. But there's lots of fights about whether and to what extent insurance providers have to cover telehealth. Then there are concerns about data and network security. And of course, telehealth is not a cure-all. There are still lots of services that you have to seek in-person care for. Now, is there a need for teletherapy? I would say yes. Michigan, again, has one of the most severe shortages of mental health professionals in the nation. So we talked about the shortage in beds earlier, but it's also true that Michigan has a shortage in people who can care for patients in need of psychiatric care. And there's a problem with distribution. 33 of 83 Michigan counties don't have a single psychiatrist. So there's a problem with the number of providers, and there's a problem with the distribution of providers. And what are some of the government barriers that prevent Michigan from increasing access to medical care providers and increasing the distribution? So one is that some states have the law that patients and medical care providers have to have an existing established relationship before they can use telehealth. Michigan actually doesn't have that law, but I wanted to mention that for everyone. Another law that often limits what medical providers can do is called scope of practice. And a scope of practice law is a law that defines what each type of medical provider can do. So a nurse's scope of practice is different than a physician's and is different than a clinical licensed social worker or a psychologist. But the problem is that sometimes these scopes of practice written by legislators are too narrow and don't allow the individual to do everything that they were trained to do. And in that case, you do have providers maybe in the state, but you're not allowing them to operate at full capacity. And then finally, the thing we're going to talk about most is that practicing teletherapy is illegal across state lines in most states. That's because most practitioners only have an occupational license in the state where they live, and that ends up meaning that they can only see patients in the state where they live. So an occupational license is the legal requirement of seeking permission from the government to work in a certain profession. And we're all aware of occupational licenses probably for doctors and lawyers and accountants, but as it turns out, there's actually occupational licenses for way more professions than that. In the 1950s, only 1 out of 20 workers needed a license to do their job, and today that number has skyrocketed to 1 in 4 workers. So the government is obviously licensing a lot more than just the typical examples we think of. And obtaining licensure is burdensome for most people. It takes education or experience, and then it involves passing some exams. Then you have to file the application with the state, which could involve fingerprinting or background checks and other timely things. And then if you actually get the license, you have to pay annual dues every year to maintain the license. You might have to do continuing education requirements. So there are a lot of hurdles that might keep people out of professions and keep the profession from growing. And the graphic on the right side of the slide is to show that there are lots of alternatives to licensure. The very bottom of the inverted pyramid says licensure, and all of the steps above licensure are other less restrictive means for regulating occupations and industries. And so it's really would be the hope that government would look to some of these other alternatives before turning to licensure. Licensure should really be the option of last resort. But unfortunately, that's not often the case, or not always the case. So what happened with these types of laws during the pandemic? Again, these laws were too restrictive and didn't allow providers to be flexible in responding to the pandemic. So many states started loosening their occupational licensing laws and their scope of practice laws. So we saw quickly that states said, all of a sudden, out-of-state doctors and nurses, you can come to our state and you can work, even though you're not licensed here. And we also saw states expanding scope of practice, which means that maybe nurse practitioners all of a sudden didn't have to work under the supervision of doctors, or other professionals could provide more services that they hadn't been able to provide in the past. And many states loosened telehealth laws to allow for interstate practice of telehealth and teletherapy. And this was really important because it gave patients lots of options to find care, especially in the mental health world, where you could suddenly look to other states to find therapists and mental health services. A lot of them lend themselves well to teletherapy and to online services. So many states loosened their telehealth laws, but a lot of those waivers that were in place have expired already. However, waivers remain in 17 states today, but unfortunately, Michigan did not loosen its telehealth laws at all during the pandemic. So at no point could Michigan residents seek care, mental health services from a provider outside the state of Michigan, even though we know we have a provider shortage. Okay, so those are some of the challenges. What are some of the solutions? Again, we can go to our state capitals and ask our legislators to change the law. We've seen some sweeping reforms in Connecticut, Arizona, and Florida. Connecticut has codified its waiver and put it in place through June 2023, so that means out-of-state providers can practice telehealth with Connecticut residents through 2023. And Arizona and Florida have gone a step further and adopted their waivers permanently, so outside providers can provide telehealth or teletherapy to Arizona residents and Florida residents permanently. And these are pretty big reforms that wouldn't have happened if it weren't for the pandemic and the acknowledgement of the fact that it is safe for practitioners to practice medicine across state lines. Another solution is interstate compacts. This isn't as accessible as the laws I just talked about, but it's something that's gaining traction. In this instance, states sign on to the compact, and if you're a resident of a compact state, you can get licensure in a streamlined process in another compact state, but it doesn't mean that if you're licensed in one compact state that you automatically can practice medicine in all the compact states. And then, of course, at Institute for Justice, we're mainly a litigation shop. The other thing we would do is challenge teletherapy laws in court, and we're doing just that. We have 2 ongoing cases, both with this client, Elizabeth Brokamp. She's challenging telehealth laws in DC and in New York, and she lives in Virginia, and she's asking for the right to provide teletherapy to clients in those places. Okay, so that was a lot of information. I hope you all have questions. And if you're interested in learning more about some of these topics, Institute for Justice has a report about certificate of needs. I was the lead author on that report. It's called Conning the Competition. And then we have a report about occupational licensing called License to Work. You can find those online, but I'm happy to take questions now.
Thank you so much. I'd like to remind our audience that they can continue to ask questions at slido.com using the code BARRIERS. So for our first question, what is the defense of CON laws if the claim that it will shut down hospitals has been wrong in the states that have gotten rid of them?
That's still the main claim. Every state will come and say that our system is unique, our economy is different. They like to say that our numbers of Medicare and Medicaid patients are different, or our number of rural hospitals are different. They make these types of arguments. And they hire their own consultants to try and prove why their state is different than other states. But we've seen success stories in all the states that have repealed their certificate of need laws, so there's no reason to believe that anything bad would happen to hospitals if we were to repeal certificate of need laws in new states.
Our next question is, are there any particular states where the Institute for Justice finds it particularly harder to legislate?
I would say it depends on the issue that we're legislating. I'll say, for instance, Michigan is a hard place to work on certificate of need laws. They don't usually move out of committee, and sometimes, so that's the first stage, and after you've drafted the bill, it goes to committee, and you need it to move out of committee to be voted on by either of the chambers, and if you don't have support from the committee chair, then your bill isn't going to move. And sometimes it's just the personality of, or the wishes of the committee chair. And so if you don't have a good relationship with the chair, or if the chair just doesn't agree that con laws are a bad thing, then you don't have a chance of moving a bill.
How do certificate of need laws help or hinder the quality of care that hospitals can provide? Do the regulations increase the quality of care, even though access is restricted?
They haven't been proven to increase quality of care. Some studies come back and say the findings are neutral, and some studies come back and actually say that they decrease quality of care. And again, that's a function of the fact that there's no competition in the market. Quality would increase if hospitals had to compete against each other and win their patients that way.
With the evident costs medical facilities are facing, does the Institute for Justice see a lot of support from these facilities, financial, political, etc.?
Unfortunately, no. I'm assuming this question means, do we see support in our work for repealing cons? And we don't see support from hospitals in that work. Hospitals, at least ones that have certificates of need, want to keep their certificates and want to keep these laws on the books. On the other hand, we do see support from the outsiders, the ones who want to build a new hospital or create a new home health agency or maybe add more psychiatric care beds. Those are the people that do partner with us because they're the ones being kept out of the market.
What is the legality of using a VPN to sidestep government restrictions on telehealth?
I don't know the answer to that question. I would assume it's still illegal. I don't think that's how the government tracks whether or not you're speaking with an out-of-state provider. I think it's just the provider's duty to ask the patient every time where the patient is located, and so it's up to the patient to be honest, and it's up to the provider to also be honest in those circumstances, and that's part of a provider's scope of practice, actually. So they could lose their occupational license if they were disregarding laws and just seeing patients from other states.
Who serves on the CON approval boards? Is it a self-serving situation where the members of the board are supported by hospitals that have CON approval?
Yes, that's what we see in most states. That's true in Michigan. The law did change last year to allow 2 members of the board to be members of the community, members of the public, but the majority of the members on the con board are associated with hospitals.
What is the main reason for states like Michigan to not pass bills to ban CON laws, other than market change?
I truly think it's the pressure from the hospitals, and you can understand right now it's hard to pass a bill that would affect hospitals. They would say, you know, we've gone through this hard time with COVID, our finances are in flux right now, you shouldn't do something that's gonna mess with that right now, we're in a difficult spot, and it's the same kind of stuff like that. On the other hand, there's also the desire on the government side to have control and have centralized planning over different elements of our society. So, you know, there's the fact that government might not want to relinquish control of something as big as the medical market.
Science and human knowledge has increased significantly since the 1950s. So is increased licensing bad? Or are we becoming more advanced in our professions?
That's a good question. So we have to start with what is the purpose of licensing? And the purpose of licensing is to protect the public from true health and safety risks. So if all of the licenses that are increasing, you know, all these new licenses that are coming out, if they're addressing true health and safety risks, then, you know, maybe they're all valid. But when we look at the type of licenses that are being created, for the most part, we see ones that don't address health and safety risks, like licenses for florists. There's no health or safety risk there to be protected from. Licenses for interior designers, and lots of things like this, professions that don't need to be licensed, but instead they're forced to jump through all these hurdles and pay all this money to the government every year just to practice their profession.
Do things like suicide prevention hotlines count as telehealth?
No, those don't, but also those are operated usually you're connected to someone in your state if you call those.
Is it costly, time-wise or money-wise, to research and get data to back up your challenge/appeal to a law?
Yeah, it usually is. One thing that helps, I guess, for certificate of need challenges is that most states make all of their certificate of need applications public. Unfortunately, Michigan doesn't. But that's a good starting place to figure out kind of how the certificate of need system operates and if the board is granting a lot of applications or denying a lot of applications, and you can see what level of detail goes into each application. So that's a good starting place, but yes, it is timely and costly to research all the specifics that you need to prove a case.
Is the shortage of psychiatrists in Michigan a result of certificate of need laws?
No, so certificate of need laws address facilities and beds in this context. So certificate of need laws restrict the ability of new psychiatric facilities to be built and the ability of existing facilities to add psychiatric care beds.
What has been your favorite part of work at the Institute for Justice?
My favorite part is just getting to represent our amazing clients. We find really amazing clients who are excited to fight for their rights, but they understand also that they're not just fighting for themselves, they're fighting for, you know, everyone's right to do the thing that the government's restricting them from doing.
Could certificate of need laws be artificially suppressing the salaries of psychiatric professionals, thus hurting the amount of people hoping to go into this line of work?
So it's actually occupational licensing that would affect the salaries of professionals. And I don't know if I think they might actually increase the salaries of the professionals, because once you get the license, you're kind of in this closed group that, again, it's sort of like the con process where you're keeping people out, but it's for licenses specifically, that you're in this group and you are the only ones who can provide this service. and there's lots of hurdles to entering this group. And so that's, part of the problem with increasing mental health care, access to mental health care providers, and increasing the number of available mental health care providers.
This is our last question. Can you explain the deleterious effects of a healthcare system that is not privatized?
I think that's beyond, unfortunately, I don't have a good response to that. I think it's beyond the scope of today's discussion, so I'm sadly not going to be able to respond to that one.
That concludes our Q&A session. I hope that you will all join me in thanking Jaimie Cavanaugh for her time here today.
Thank you all.